so our last seminar is really going to cover law updates, and I think Marcus is going to be leading this one, so I'll let him take over.
Well, and we got the benefit, at least Mr. Brannigan is sitting at the table here. He's going to be, so when we open up for questions and I miss something, I'm going to be relying on Matt Brannigan here a little bit to fill in the blanks, at least on the Bach versus Liberty Mutual Fire Insurance Company case. But the citations are up there. I think it's worthwhile at least to start procedurally with the fact that, you know, really this issue hadn't raised its head until in Western National Insurance Company versus Wynn, 902 Northwest 2nd, 645, Minnesota Court of Appeals 2017 opinion that we're going to be talking about. It was a matter of first impression, which is interesting since 62Q.75 was amended directly referencing reparation obligor under the Minnesota No Fault Act back in 2005. And with that, in 2009, 65B54 in the No Fault Act was amended to require electronic submission for claims by a, quote, health provider. These two cases are specifically going to be addressing the issue, and that's why we decided to tackle it today, because it's at least an issue that I myself have seen as an arbitrator on the last 6 arbitrations I've handled. So it's raising itself as an issue, and it's the changes in the law that you as arbitrators have to be aware of, at least moving forward. The background on the Western National versus Wynn case is interesting too, because as it turns out, it was petitioned for review to the Minnesota Supreme Court, but it was at the exact time that Justice Strauss was appointed to the 8th Circuit Court of Appeals. So procedurally, we were left with an affirmance without an opinion, a 3-3 split. So under the appellate rules, that means there is no opinion, and the Court of Appeals opinion stands, being completely affirmed without a written opinion. In context, in January 2011, Mr. Wynn sustained injuries in a car crash, and he was in the course and scope of his employment. At that point, after workers' compensation benefits had ended, Western National then paid some no-fault benefits. After that, in May of 2012, Mr. Wynn was requested to attend a medical examination at the request of Western National, and following the exam, it was determined that there was no further medical care or treatment that was reasonable or necessary. So the matter then proceeded to the first arbitration in the Wynn case, and based on that medical exam, notification of the denial of benefits occurred, and then a petition for no-fault arbitration was filed, and the first arbitration was had. In January of 2013, the no-fault arbitrator, the first no-fault arbitrator, denied Mr. Wynn's claim in its entirety. Subsequent to that, in February of 2014, to get the timeline down, Mr. Wynn then started treating with the Center for Diagnostic Imaging. And CDI then submitted one bill to Western National for payment for one of the first visits. Western National responded to CDI saying that based on the previous medical examination, Western National is making the determination to deny coverage for that treatment based on the previous medical exam and the results of the January 2013 arbitration. So Mr. Wynn continued treating with CDI, but CDI did not submit any additional bills to Western National. When the treatment was finished with CDI near the end of 2014, the treatment charges exceeded $10,000. So in April, to waive stay in the jurisdictional limit, April 2016, Mr. Wynn filed again for no-fault arbitration against Western National, seeking payment of those CDI bills that weren't paid. Western National made the assertion that under Minnesota Statute 62Q.75, subdivision 3, that as a defense to the claim, Western National is not going to pay the bills. A different arbitrator conducted a hearing, and in the second no-fault hearing, Mr. Wynn was awarded $11,695.23 in medical expenses, interest, and the arbitrator fee. Subsequently, Western National brought a motion in district court to vacate the award, and in January of 2017, the district court granted Western National's motion and vacated the award for arbitrator's fees, but all but the $1,027.25 of the award for medical expenses, and that presumably is related to the initial care and treatment that was submitted by CDI. And that, again, the value of the bill that was submitted in 2014. The district court also made the conclusion and rendered the conclusion as a matter of law that Minnesota Statute Section 62Q.75 applied, and that because CDI had only submitted one bill to Western National within the 6-month time frame under the statute, CDI could not collect its remaining charges. So aside from the medical expenses for one visit, the district court determined that Mr. Wynn did not experience a loss under the Minnesota No-Fault Act that would entitle him to no-fault benefits. The district court concluded that the medical expense benefits never became due because CDI did not submit its claim to Western National pursuant to the Uniform Electronic Transaction Standards, promulgated under the No-Fault Act under 65B.54 subdivision 1, which requires healthcare providers to submit claims according to approved electronic standards and prohibiting healthcare providers from directly billing the insured when the claim is not remitted to pursuant to those standards. Finally, the district court also issued a finding of fact and conclusion of law that Mr. Wynn is not personally obligated to pay CDI's outstanding charges, and that is what gave rise to the appeal to the Court of Appeals. The Wynn panel and the Court of Appeals analyzed language under 65B.54 first to make a determination as to when a loss accrues. So according to the reasoning of the court, a loss accrues not when the injury occurs, but rather when the medical expenses are incurred under the No-Fault Act. And an injured person incurs medical expense as he or she receives bills for medical treatment. Mr. Wynn argued that 62Q.75 could not bar his no-fault claim because the statute only governs claims between healthcare providers and health plan companies, and he is not a healthcare provider. Again, since this was a matter of first impression, the Court of Appeals sought to interpret 62Q.75 to decide whether it applies to the determination of whether an individual is entitled to no-fault benefits, and it went through its analysis trying to determine the legislature's intent. Starting with the background of the Minnesota Health Plan Contracting Act, which sets forth requirements for contracts between healthcare providers and health plan companies. Now, historically, and the history behind the statute that's outside of the opinion, the addition of reparation obligor was kind of a second passing push through in terms of the definition of the statute. So if you would pull the Minnesota Health Plan Contracting Act in its entirety and review it, everything within that act itself relates to healthcare providers and health plan companies. So the court had to construe both statutes together. The this being 65B54 and then the provisions in 62Q.75 to reach its conclusions. And under that provision, health plan companies must either pay or deny clean claims within 30 days of receiving a claim. And by definition, a clean claim is a claim that has no defect or impropriety and doesn't lack any required substantiating documentation. It also establishes under 62Q the timeline for healthcare providers to submit charges to health plan companies. And the language there that's crucial is a health care provider or facility that does not make an initial submission of charges within a 6-month period shall not be reimbursed for the charge and may not collect the charge from the recipient of the service or any other payer. After analyzing this section, which by its own acknowledgement, the court indicates that the statutory chapter does not generally apply to no-fault insurers, the court construed that the more specific language of 62Q75 expressly states that it does apply, and compared the definition of the Health Plan Contracting Act to the other provisions of 62Q to reach its conclusions. So after running through that gambit, ultimately the court determined that Minnesota Statute 62Q applies to healthcare providers seeking reimbursement from no-fault insurers. And in its reasoning, the court made a conclusion, reached the conclusion that in this particular case, with the exception of one bill, CDI didn't bill Western National within 6 months of providing treatment to Mr. Wynn or of knowing that Western National was the responsible health plan company. And therefore, held the court, CDI could not collect those charges from Western National or Mr. Wynn. If, in the court's reasoning, the healthcare provider does not follow the statutory method for submitting bills to the insurer, that claim is not due. Because CDI didn't submit the bills to Western National, it could not have complied with the electronic transaction standards required by Minnesota Statute 65B.54, and therefore, the court's second conclusion, under Minnesota Statute 65B.54, Subdivision 1, CDI cannot therefore seek payment from Mr. Wynn. Mr. Wynn made the argument that even if he does not owe CDI for his medical expenses, Western National is still obligated to reimbursement because he incurred a loss under the No-Fault Act. His argument relied on the Supreme Court's determinations in Leonardson and Stout, holding that even if an insured fully recovers claimed medical expenses through a tort action, the tort recovery doesn't reduce or eliminate the insured's recovery of no-fault benefits for the amount due. The Court of Appeals in Wynn distinguished both Stout and Leonardson, indicating that those cases concerned whether a later event could have a collateral effect on the amount of loss. In this particular case, the Court of Appeals indicated in their reasoning that this case involving Mr. Wynn does not involve a subsequent event that either modified or eliminated Mr. Wynn's amount of loss. The issue here, according to the Court of Appeals, is whether a loss ever accrued. In the court's reasoning, in the no-fault context, if the healthcare provider does not comply with the time requirements indicated in 62Q.75 or the submission requirements of 65B.54 under the Minnesota No-Fault Act, the insured claimant does not incur medical expense because he cannot be liable for a charge that the healthcare provider may not collect for a bill that is not due. So, under the circumstances, what does that mean? And what's the current state of the law? We have a published opinion from the Court of Appeals now that indicates if a provider doesn't submit bills to a carrier or no-fault insurer within 6 months of the date of service, then the insured can't collect at arbitration and the provider can't collect from the insured. And the second prong, which is the analysis under the No-Fault Act and the provisions under 65B.54 requiring electronic submission by the provider, if that provider doesn't bill electronically, then the insured cannot collect at arbitration and the provider cannot collect from the insured. Sounds simple? Not so much. We subsequently, in June of 2018, a second case dealing with the 62Q.75 issue made its way up to the Minnesota Court of Appeals against Liberty Mutual. And this is the second case cited the Bach versus Liberty Mutual Fire Insurance Company case. And one of our members, as I indicated, Mr. Brannigan, was involved in that appeal. The facts, at least as stated by the court, Ms. Bach left a restaurant and walked to a car that was parked in a lot across the street. Her husband was waiting in the car. He drove forward and opened the car door for her. She put her hand in the door frame and attempted to enter the car, but ultimately fell into a trench in the parking lot after she had tripped. As a result of the trip and fall, she fractured the fibula on her left leg and incurred expenses in excess of $20,000, was unable to work 18 weeks and 3 days, and initially the health insurer paid her medical expenses. Ms. Bach brought suit against the parking lot owner, and the case was resolved. The health insurer exercised subrogation rights and recovered some of the medical expenses it had paid from the settlement with the parking lot owner. And at the time of the incident, Ms. Bach had no-fault coverage through Liberty Mutual, and in September of 2014, she applied for no-fault benefits related to that injury, and Liberty Mutual subsequently denied the claim. In October of 2016, Ms. Bach sued Liberty Mutual, seeking in part a declaration that she was entitled to no-fault benefits under her policy, and then ultimately the parties filed cross motions for summary judgment, with the district court granting Ms. Bach's motion and denying Liberty Mutual's motion, eventually awarding Ms. Bach $39,000 and change, and Liberty Mutual subsequently brought the appeal. Now, the court went through the first part of its analysis indicating whether Ms. Bach had a covered claim for no-fault benefits, and that related to a determination of a injury arising out of maintenance or use of a motor vehicle. So the court spent a lot of its time, at least with the first section of its analysis, dealing with the articulated steps that we know, the Klug factors applying to whether an injury arose out of the maintenance or use of a motor vehicle. If you don't remember them, first you evaluate the extent of causation between the automobile and injury, and you look at whether it's something less than proximate cause in the tort sense and something more than the vehicle being the mere site of the injury. This causal connection then is established if the injury is a natural and reasonable incident or consequence of use of the vehicle. Third, the vehicle must be an active accessory to the injury that's sustained. So with the court then determined if the injuries that she sustained resulted from the maintenance or use of a motor vehicle for transportation purposes, and indicated, at least in the first part of its analysis, that Ms. Bach indeed established a sufficient causal connection between the use of her vehicle and her injury. And the court went to compare and contrast at least the decisions dealing with similar causal connections, one of which was the power line case in Haagensen, and then discussing the North River case. And Liberty Mutual made an argument that the court should follow the Supreme Court's opinion in Markland, where the plaintiff refilled his gas tank, finished, replaced his gas hose, and then walked towards the passenger side of the vehicle. And as he passed the right rear of the vehicle, slipped on a patch of ice and was injured. This panel, the Court of Appeals, determined that they weren't persuaded that Markland applies because, as discussed, the plaintiff did not come into any physical contact with their automobile. And in addition, the court determined that Markland juxtaposed facts similar to those in Bream versus the Illinois Farmers case, where the court held the claim was covered under no-fault policy when a plaintiff was injured while washing his car at a service station after he slipped on a patch of motor oil. So going through all of these steps, at least on the required Klug factors, the court ultimately reached a conclusion that there was no other intervening act to break the causal chain here, and that Ms. Bach satisfied the test because she was ultimately using the vehicle for transportation, and ultimately concluded that the district court correctly determined that the claim was covered as an injury arising on the maintenance and use of a motor vehicle. Now, the second portion of the decision and the appeal related to whether any actual prejudice exists as a result of a delay in providing written notice to Liberty Mutual of her claim. The claim itself wasn't submitted for 16 months, and the Minnesota law authorizes at least a provision in a plan of reparation security that can prescribe a period of not less than 6 months, requiring notification to the reparation obligor or its agent of the accident and possibility of a claim for no-fault benefits. Liberty Mutual argued that its lack of opportunity to investigate and conduct its own independent medical exam or defend the claim at or near the time of the accident caused actual prejudice, and so that Bach therefore would be ineligible to receive any no-fault benefits. Specifically, it argued Liberty Mutual was unable to take photographs, obtain witness statements, preserve evidence, analyze medical bills and treatment, and question Bach under oath. The trial court rejected this argument because Liberty Mutual didn't produce any admissible evidence that specifically described the nature of any actual prejudice that it had sustained. At most, the only thing the record supported was a general assertion that the delay prevented Liberty Mutual from conducting an immediate investigation of the claim, including physical conditions of the parking lot where the injury occurred. Similar in Bach's case, Liberty Mutual failed to establish that it experienced any actual prejudice. It didn't allege any facts suggesting a different version of events, and it did not allege that any of Ms. Bach's medical costs were unreasonable or unconnected to her injury. And furthermore, Ms. Bach's family took photographs of the trench, and Liberty Mutual did not claim that the parking lot had changed. In addition, Liberty Mutual obtained statements from Ms. Bach and her family and offered no reason it could not obtain an examination of Ms. Bach under oath. And lastly, Liberty Mutual had not identified that any evidence was not preserved. After analyzing those factors, the Court of Appeals made a determination that the district court correctly determined that Liberty Mutual failed to offer any evidence that Bach's delay in providing notice resulted in actual prejudice. Now, the third part of this decision, so we're getting three different applications of law as it applies to the context of what you can potentially see as a no-fault arbitrator. The third part of the decision then deals with the 62Q.75 argument. The argument by Liberty Mutual was that Bach's healthcare providers failed to submit charges to Liberty Mutual within 6 months of treating her, and its failure to do so required, in the manner it required, that she couldn't recover under no-fault benefits. But The court went through the same analysis and actually cites the Wynn decision. It starts out by quoting the statute 62Q provision indicating that healthcare providers must submit their charges to a health plan company or third-party administrator within 6 months from the date of service, or the date the healthcare provider knew or was informed of the correct name and address of the responsible health plan company or third-party administrator, whichever is later. An emphasis on those last 3 words, whichever is later. The court then referred to the provision as subdivision 3, which is a lot easier than rattling off 62Q75 all the time. But the context of the decision notes that the no-fault insurance contract in and of itself also applies to reparation obligors for treatment under an injury compensable under Chapter 65B. So you had an internal reference to the language we discussed under 65B 54 in the Wynn decision. Box healthcare provider submitted her charges to her health insurer for medical care related to her injury, and Liberty Mutual argued that it's not obligated to provide no-fault benefits for medical costs because the healthcare provider failed to submit charges to Liberty Mutual within 6 months of the date of service. The trial court rejected this argument. The Court of Appeals determined that they agree with the district court in this circumstance because the healthcare provider did submit charges to her health insurer, and Bach incurred a loss under the No-Fault Act as a result. And 2, because there's no evidence in the record that Bach's healthcare provider had been informed that Liberty Mutual was the responsible insurer. So the court ran through the analysis in Western National versus Wynn and applied the terms of the Wynn decision indicating that the court recognizes subdivision 3 sets out requirements for healthcare providers, not insured parties. Recognizes and quotes language from Wynn saying recognizing subdivision 3 is silent about insured claimants and unambiguously requires only healthcare providers and facilities to comport with its provisions. So in contrast to Wynn, this panel of the Court of Appeals determined that Bach incurred a loss when she incurred medical expenses and received bills. Also, Bach's healthcare provider submitted charges to Bach's health insurer. Liberty Mutual also failed to establish that Bach's healthcare provider violated subdivision 3's timing provisions, even though there is a concession that the healthcare provider failed to submit charges to Liberty Mutual within 6 months of service. But according to the Court of Appeals in the Bach case, subdivision 3 states that healthcare providers must submit their charges within 6 months from the date of service or from the date it was informed of the correct name and address of the responsible health plan company or third-party administrator, whichever is later. The reasoning of this court, accordingly, subdivision 3 implies that a healthcare provider is under no obligation to submit charges to an insurer until it's been furnished with the pertinent information to do so. And Liberty Mutual pointed to no evidence that Ms. Bach's healthcare provider was informed that Liberty Mutual was the responsible insurer. So as you can see, the law is really clear. That's why predominantly it would have been nice if the Supreme Court would have made a determination on the issue, but now we're currently, as we sit here, we're in a state of flux. You know, if the holding, you look at the court's holding on 62Q, a loss was incurred when the bills were submitted to a health insurer. There's no evidence in the record that the provider had been informed of a no-fault insurer. And you couple that with Bach's holding on 65B 54, that it only regulates explicitly how health providers must submit claims. Liberty Mutual didn't allege that Ms. Bach was a health care provider, and it cannot deny her claim on the basis of that as a result. So that puts you in a dynamic between what facts are going to be presented at now an arbitration hearing that would be crucial, at least for your determination, because this is going to be more and more complex issue that's going to, again, present itself. So, Mr. Brannigan, did I miss anything from?
Well, no, but I think the important part about my case was that the bills, and I didn't represent her during the liability, I did not bring the no-fault claim, but they were submitted to a health care provider, which is what the statute says. It was her health insurance company, which paid the bills well within 6 months, And so I think if you're looking at it as an arbitrator, we used to sort of think that 62Q didn't apply to the no-fault situation, but of course, WIN now says it does. And if those bills are not submitted, where in WIN they were just sent to the attorney's office, then I don't think that the health care provider has done what they need to do under 62Q, and you can't award them. It's sort of my interpretation of those two laws.
And in WIN, they clearly knew the carrier because they submitted a bill to Western National beforehand. So
Yeah.
that fact is missing in the Liberty Mutual.
Did the petition get filed in the Bach one?
No, it went right into district court. And I got it, and I just filed a tech act,
Was it?
or a contract action, actually.
Well, they denied it, right? Didn't they deny it? Didn't you submit it?
No, yeah, I got the case referred to me from a very learned attorney.
I meant the petition for review to the Supreme Court get filed.
No, they just paid it.
And I will say this about Nguyen as well. The initial bill was submitted by TDI. Western National responded with a letter saying, do not send us any more bills. We are not the responsible payer. And so TDI said, okay, I guess we won't send any more. And then that was one of the big issues at the Supreme Court. Three of the justices were saying, well, wait a minute, why are they getting off scot-free when they said, don't send us any more bills? We're not the responsible payer. But now Western National is arguing they are the responsible payer. And the other three justices sort of, it was a 3-3.
Well, and procedurally, what I find troublesome too is the fact that the Court of Appeals raised an issue that wasn't even briefed. 65B 54 argument wasn't raised by either of the parties. I mean, the court can unilaterally bring it up on their own, but it didn't apply under the circumstances of that particular opinion. So,
Well, I will also say that in this electronic submission issue is an issue since there are a lot of smaller no-fault carriers that are not set up to even receive things electronically yet. And it becomes a real problem. And I've had cases where a provider has billed, or I give somebody the no-fault information so they can bill, and the no-fault carrier says just mail us the bill. And they mail the bill. And they pay them, and then there's a cutoff eventually, and then when we get to the hearing, the defense attorney says, wait a minute, these were never submitted electronically, we don't owe them. And I will say this too, there is no timing requirement on the electronic submission.
okay.
So you could the bill could be 5 years old, and you could electronically submit them the day before the hearing. It's okay, it's silly, but it's okay under the law, which doesn't really make sense, but you have to have notice of the bill within 6 months, or have it submitted, but it doesn't have to be electronically done within any certain time period, which just creates more absurdity.
The way I read WIN is that you have to do both within the 6 months. That you don't have, there's no time limit under 65B 54. But the 6 month requirement, the way I read it, requires both. That they would have to be submitted electronically within 6 months. And that was, and I think the real curveball came when the little piece about applying to reparation obligors got into the Health Care Contract Act. And I don't know how it got in there. I'm not familiar at all with the legislative history, but it's clearly in there. And that's what the law says. And with that 3-3 tie at the Supreme Court level, it's got affirmed.
I will reread.
Would have been interesting. I'm still wondering how it would have
on the electronic 6 month, but it's not in the statute for the electronic.
No, that's what I perceive as a conflict. If you're going to read and reason to apply both statutes together, then you have to give both statutes in statutory construction, applying, the 600 series to apply the statutes of statutory construction to it. Both have to be given their weight, and that leaves an open question for everybody that's serving as an arbitrator. Of all of the factual scenarios that are resounding in both Wynn and Bach now have to be factual determinations that are made by the arbitrator if the issue itself is raised as an affirmative defense. So that goes back to the same issues before that we started with. It's like, okay, where do I ask the questions? How do I move this forward? Is it part of the case? Is it not part of the case?
Is that a factual finding that an arbitrator can do, or is that the application of the law, which we're not allowed to do?
Well, it would be a factual finding to determine when the bills were submitted, how they were submitted, did another health insurer pay? I mean, those are ultimately fact issues that have to be determined before you can even apply
Can we
it.
apply it to the statute, though? I am denying these bills because based on 62Q75, which I interpret to mean this, I mean, we can't do that.
Well, I don't think we can interpret it, but we are required actually to apply the law. And so somewhere along the line, it does get kind of gray. Are we interpreting it when we apply it?
I don't think this was covered, hit me if it was, but is there a bright line rule of who holds burden on 62Q arguments? Is that the respondent or claimant?
So it's a basis of denial, it becomes an affirmative defense.
Yeah, I might take it as it's an affirmative defense, like comparative fault or whatever, and then the burden would be on the party who raises the affirmative defense.
Okay, the question was, for those people that are on the phone, is whether raising the issue of 62Q.75, what is it? And the responses were that it would be treated as an affirmative defense. Any other thoughts? I mean,
Well, as an arbitrator, I think I would require the party, if that issue was presented to me, I would require them to submit a letter brief. Guide the hearing open for a week or 10 days, submit a brief, and then make the decision.
The other thing that's ironic about it is that Bach's unpublished, and within the Bach opinion itself, it's a very prominent footnote, because Liberty Mutual cited an unpublished decision for their position. And the Bach court goes, oh, no, unpublished decisions have no precedential.
Yeah. And that's what puts us in this construct. I mean, as we sit here today, Western National versus Wynn is the law, no different than making a determination of whether medical expenses are reasonable and necessary, or making a determination as whether replacement service benefits are due and owing, or income loss and disability benefits are due and owing. We're relegated to make factual determinations by applying the provisions of the no-fault law, and we just have to be aware of it as arbitrators that these issues are becoming normal, at least where I am, as seeing as issues that have to be dealt with.
Are they still making the plaintiff's argument that it doesn't apply, 62Q doesn't apply to no-fault claim after the Wynn decision? I haven't seen plaintiffs making that argument since the decision.
No, and now the arguments are based, it is all factual, it's based on submissions and timing.
So the insurance companies aren't making it as an affirmative defense because either they're complying or
They're not, yeah. Any other thoughts, ideas?
I guess to that end, what I'm seeing is there's kind of a copy-paste blanket defense that gets thrown into every single arbitration brief right now. That I'm finding that going into a hearing, I don't even know if they're asserting a 62Q defense or not, and that's one of the things that I'm asking as a claimant's attorney every single time before the arbitration begins. Are we dealing with an active 62Q defense or not? It's just being thrown out blanketly, which is why I asked the question about burden, because typically, along with that blanket defense, is not, and I understand proving a negative is difficult, but they're going to then have to show that these bills were not submitted in accordance with 62Q in order to assert that defense. But I'm seeing it just as a blanket, we're going to throw it out there in every single case and see if someone bites on it. And my response to that is, well, there's bills owing, there's bills submitted, there's petition filed, all of that's timely. And I don't have any information to suggest otherwise. But that's oftentimes the push-pull that we're seeing, whether it be from a claimant's attorney, respondent's attorney, or arbitrator.
I mean, I can't say as an arbitrator, and I probably do 5 a month or maybe more. I don't see them making that argument anymore since when. Now, if they did, then they got to, I take it as an affirmative defense, you got to show me, in fact, those submissions were made. I think the burden flips to them.
Right.
On those situations where you see it, and I see it also come up from time to time, do you have sort of a Stawley type of issue where it was never raised in the initial defense to the claim, and then only comes up later as an additional defense when they submit their statement of the case to you? Does that make a difference? Because if the defense is never raised, sort of like the claimant never files, for certain bills incurred pre-filing within 30 days, those bills are lost. And he doesn't make the subsequent. It doesn't make the subsequent within 30 days, right? And from the defense perspective, the rule is the exact same. All your defenses have to be submitted within 30 days. And if those don't get submitted or are never raised until the time of the hearing, essentially, are those waived?
So what he's saying is that they typically now, in the respondent response, they throw in the kitchen sink, and so it is raised even though it's not seriously raised.
So those of us that are on the phone, the issue was raised, okay, if 62Q.75 subdivision 3 defense is raised in kind of a blanket defense to a claim, is it a type of Stawley situation where, the defenses have to be raised within 30 days and have to be notified about, and is it treated as a true affirmative defense, and what to do in that regard? So the moral of the story is findings of fact on these particular issues, if it is an issue, in order to make, follow up with particular issues if it is raised as a defense. And like we talked about early in the morning, questions to clarify the record, but it's not the party's burden to prove a claim nor prove an affirmative defense. So at least the arbitrator, not the party.
Are there any other questions or comments in the room?
I have and I don't want to take any more time, too much time, but this came up last week, and it was a question of a claimant didn't attend a statement under oath, despite being asked 7 times to do so. I had told the party that I didn't feel like I could make a legal determination, but I would make findings as to whether the request was reasonable and whether the refusal to attend was reasonable or not. And then just so they would have a record, they had a court reporter there so they could go on. Did I do the best practices kind of thing, or is there a better way to handle something like that?
Well, findings, making factual findings. I mean, that's all you're...
Is that illegal? Could I have made that decision that you can't get any of these awarded because you didn't come to any of the statements under oath? I mean, is that something an arbitrator can do? Deny the claim entirely because they didn't attend that?
I would say yes,
Yeah.
that you can.
I would think so.
Okay.
That's a coverage issue, though. I've gone through that.
I've had that question several times. I've simply said, we're going to delay the arbitration until you comply with the contract, give the statement of oath, part of the contract, they're entitled to it. We'll hold the arbitration after.
It's kind of a slippery slope, though, when you're dealing with a coverage issue. You can make factual determinations as to the reasonableness of the request and the unreasonableness of the failure to attend, but to the extent you're trying to import coverage determinations, then you're borderline on making a legal determination as an arbitrator.
But what do you do with the case law that says, you're going to find that it's not reasonable to attend? Let's say that's your determination. Any of the bills incurred in that period until they actually go to an IME, they can't collect on. That's the case law. Those bills disappear if you fail to reasonably attend, if that's your decision as an arbitrator. The bills in that.
That's for an IME, that's under Weaver.
Right, yeah, right.
Right.
This is statement under oath. That's
Oh,
all.
okay, yeah, statement.
Right.
It's still a cooperation thing, I might do the same thing. But anyway.
Because I have heard that exact scenario that's been described, and I'm sitting there thinking, why don't defense lawyers do what I did a few times when I was a defense lawyer, and if they refuse multiple times or whatever, to write their lawyer and say, we're considering starting a deck action, or get a non-cooperation letter from the adjuster, send them that. I found that lubricated things quite well.
But not a non-cooperation letter does not necessarily.
Not all the time, but when you're just, you're on the no-fault side and you're looking at that and somebody wants you to, I don't know, I just try to avoid coverage stuff as much. I would say in that situation, say to the parties, if you want, I'll be glad to continue the hearing, and if you want to go, get your coverage decision and then come back if you still got a claim. But
I kind of fall in your camp, Bruce. Thank you so much for you people attending. We appreciate it.